Welcome to part 2 of our discussion on the law on contracts. In part 1, we talked about the essential requisites of a valid contract. In part 2, we will talk about the different kinds of defective contracts. If a contract is defective, does it automatically render the contract invalid? Well, before we talk about the remedies, if a contract is defective, let's talk about a possible solution. First, to a defective contract. If a contract is defective because it does not truly reflect the meeting of minds of the parties on the object and on the cause or consideration, the parties may still remedy the written contract in order to truly reflect what they had agreed upon. How is that? Through reformation of the document or reformation of the instrument written by the parties after their meeting of minds. If after their meeting of minds, the instrument does not express the true intention of the parties, for failure of the document to express the same due to mistake, fraud, or inequitable conduct or accident, the parties may agree to rewrite the contract or the instrument in order to truly reflect their actual intention on the matter. This is called as reformation of the document or instrument. However, it is important in reformation that parties will again agree to rewrite the written contract which does not truly express their real intention. But the problem here is, what about if parties do not agree anymore on the reformation of the instrument or contract? Because certainly, one party was already benefited by that inaccurately written document or contract. Surely, that party will insist that, anyway, you signed, you read, you understood, you agreed on that written version of the contract, even if he or she really feels that it's not a true reflection of what they had agreed upon. Well, part of human nature, that benefited party will insist on that inaccurately written instrument. And that's where the problem will now arise. So, if reformation is no longer possible and the contract is defective for whatever reason, what will now be the repercussion of it? First, let us identify how do we classify the defective contract, because it is important to first know the classification of the defective contract for us to know the remedy available to the parties, because the remedies are dependent on the nature and kind of the defect on the contract that was not anymore reformed by parties through a reformation of the instrument. There are 4 general kinds of defective contracts: rescissible, voidable, unenforceable, and void. What is a rescissible contract? A rescissible contract technically is a valid contract. But in law, when we say it's a valid contract, it is a perfectly valid contract. No defect at all. Because if it has a defect, then it may be classified as either rescissible, voidable, unenforceable, or void. If a contract is neither of any of these kinds of defective contracts, then it is perfectly valid. A rescissible contract is a valid contract, but it is not a perfectly valid contract because it has a defect. What are the types or forms of a rescissible contract? The first form of rescissible contract is when a ward or an absentee under the guidance or assistance or supervision of the guardian or the representative, as the case may be. If the ward or absentee suffers a lesion, injury, or damage of more than 1/4 of the value of the property, when the guardian or representative enters into contracts or transactions with third persons affecting the property of the ward or the interest of the absentee. In that particular case, the ward or the absentee or any representative of the state can ask for the rescission of the contract entered into by the guardian or representative if the ward or absentee incurs damages or injury amounting to more than 1/4 of the value of their property. On the ground that while the contract entered into by the guardian or representative was valid, it was rescissible for allowing the ward and absentee to suffer a lesion of more than 1/4 of the value of the property and not being able to protect their interests or their rights. It is rescissible even if it is valid. The second form of rescissible contract is when a contract is entered into for the purpose of defrauding creditors. Like, for example, in our previous discussions, when the debtor who decides not to pay back his creditors enters into a contract with respect to his properties and sell them all to other persons so as to pretend that he is already insolvent or bankrupt. Apparently, these transactions made by the debtor are undertaken to defraud creditors so that the creditors will not be able to collect back from him. These contracts are rescissible in nature. When a property is under litigation, the case is still pending in court, or a payment as a result of an obligation in the contract is made under the state of insolvency, that contract or payment is considered as rescissible under the law. In any other situations, when there are no other remedies available to an aggrieved or injured party, the default is to consider and to allow rescission on the part of the injured or aggrieved party who is left with no more remedies under the law, particularly on obligations and contracts. However, time is of the essence. There is a period within which the injured party is allowed to have rescissible contracts rescinded. And that is only within a period of 4 years from the discovery of the damage or the defect in the contract, or from the time when the person has reached the necessary legal capacity. However, the law also allows the injured party or the aggrieved party choices in law or remedies to choose from. The injured party may decide to just forgive the one who committed lesion, damage, or injury to his or her rights by ratifying a defective rescissible contract, and through that ratification, by declaring that he has or she has already forgiven what has been committed against him or her, it will render the rescissible contract valid. But that is only one of the choices on the part of the injured or aggrieved party. If he or she does not want to ratify, then he or she may proceed with the remedy provided for under the law, which is rescission. And what do you mean by rescission under the law? Rescission is restoring the situation of the parties to the point where as if there was no contract entered into at all. Restoration to the extent necessary to cover the damage caused. So what has been delivered or paid or performed will have to be reverted back to what we call a status quo ante, the situation before the rescissible contract was entered into, as if no contract was ever entered into. Of course, together with all the ancillary damages that the injured party may claim from the one who was responsible for the defect in the contract. The second type of a defective contract is voidable contract. Voidable means the contract is valid in the meantime, but it is annullable. It can be annulled and declared void at a later time by our courts of justice, of course, an obligation being a juridical necessity. So a voidable contract is technically, again, a valid contract. But unlike a valid contract, a voidable contract can be declared void or can be annulled at a later time. Under what circumstances can we consider a contract as voidable? Well, if one of the parties' act of giving consent was vitiated by any of the 5 vices of consent: mistake, violence, intimidation, undue influence, or fraud, then the contract is voidable because that party whose consent has been vitiated could not have given consent or entered into that contract were it not due to the 5 vices of consent. Or one of the parties lacked the necessary legal capacity. Again, what are these? At least 18 years old, must be of legal age, must not be a deaf mute who does not know how to write, read, and express himself or herself. And lastly, the person must not be insane. Again, similar to rescissible contracts, the period to institute annulment of a voidable contract is only limited to 4 years. This is the prescriptive period. 4 years from the time the age of majority is attained, 4 years from the time the reason for the defect is discovered. Again, the options on the part of the injured party whose contract consent has been vitiated has options either to ratify and declare the contract as valid and forget about the vitiation of consent, or that person may proceed with annulment through our courts of justice. But in the meantime, prior to the declaration of annulment, the contract remains to be valid and can produce legal effects. The third kind of defective contracts is unenforceable contracts. A contract is unenforceable when one of the parties abused the authority conferred on him or her, or that person has no authority to represent another. This can be seen in a contract of agency, particularly when the principal has granted limited authority on the agent to represent him or her insofar as third persons are concerned. In agency, the agent has limited authority as conferred by the principal. When the agent abuses such conferred authority from the principal, or the agent does not have any authority at all to represent the principal, the contract entered into by such agent is considered as unenforceable. In voidable contracts, when one of the parties is incapable of giving consent, or such consent was defectively given by one of the parties, it is voidable. But if both parties are incapable of giving consent, or both parties have defectively given their respective consent, the contract is unenforceable. The third kind of unenforceable contracts is when the contract has failed to comply with the statute of frauds. We will discuss later on what is the statute of frauds all about. But in the meantime, if the contract is considered as unenforceable, as falling under either of the three kinds of unenforceable contracts, then the injured or aggrieved party has the following remedies. First, it is either he or she ratifies the defect and declare the contract as perfectly valid instead of enforcing his or her rights as an aggrieved party in unenforceable contracts. Or the second option or choice of the injured party is to have it declared unenforceable or not enforce it at all for being unenforceable. Well, we need to take note that an unenforceable contract is valid, but it's not perfectly valid, there being a defect. And even if it is valid when it is not ratified, it is unenforceable and will remain to be unenforceable. Let's go back to the third kind of unenforceable contracts, which we call as failure to comply with the requirements of the statute of frauds. What is the requirement under the statute of frauds? The contract must be in writing so that the parties will be clear on the terms and conditions of the contract in order to avoid fraud. That is the requirement of the statute of frauds. It must be in writing if it is covered by the statute of fraud. If not in writing, then the document, the contract, will be considered as unenforceable. Contracts are required to be in writing only if it is covered by the statute of frauds. What are those contracts covered by the statute of frauds? You can see on screen the various types. If the contract or agreement is not to be performed within a year, not to be performed within a year, but it is already agreed upon now, it must be in writing. Otherwise, that contract is unenforceable. And so if the contract is to be performed within a year, then it would not be in writing. It may be orally constituted, and it will not be violative of the statute of fraud, and therefore, assuming all the other requisites are present, then the contract is perfectly valid, not unenforceable. Second, a promise to answer for the debt or default of another. Let's say, for example, a person will undertake to be a guarantor for the payment of the debt or default of the original debtor. If the debtor cannot pay, I will pay. You are assuming the role of a guarantor or a surety. Such kind of promise to answer for the debt or default of another is covered by the statute of frauds and must be written. If not written, then the contract will be unenforceable, and the guarantor cannot be held liable despite the oral promise. An agreement made in consideration of marriage, other than the mutual promise to marry that we had already studied in our first few lessons in obligations and contracts. If you will marry me, I will donate to you one determinate parcel of land of mine, which I was able to acquire when I was still single. That agreement in consideration of marriage must be in writing. Otherwise, unenforceable. An agreement which will tackle the property relationships of spouses. Remember, we talked about marriage settlements in the past, wherein the parties before their wedding or marriage would agree on the property relationship, if it will be a conjugal partnership of property, absolute community of their properties, or it will be a separate, complete separation of their property, which they acquired when they were still single until they get married. These agreements, these prenuptial agreements, must be in writing. Otherwise, they will be unenforceable. When a movable or personal property is sold and the value is at least 500 pesos, 500 pesos and above, it must be in writing. Otherwise, the sale of the personal or movable property will be unenforceable. However, sale of a personal property worth less than 500 pesos may be orally made, and it remains to be perfectly valid. When it comes to real or immovable property, leasing a real property for a longer period than 1 year, or selling a real property or any interest on a real property is required to be in writing. Otherwise, unenforceable. But if you will lease or rent out a condominium unit for only 8 months, even if a condominium unit is a real property, it is allowed to be orally constituted. And it remains, assuming all the other requisites are present, it is perfectly valid because the lease or the rent is not longer than a period of 1 year. In sale of real property, regardless of the amount of the purchase price, if the sale involves a real property or any interest involving an immovable property, it must be in writing. Otherwise, it will be unenforceable. However, when it comes to sale of a personal or movable property, you have to look at the purchase price. 500 and above, it must be in writing. Otherwise, unenforceable. Below 500 pesos, it is perfectly valid, even if it is merely orally constituted by the parties. Representation as to the credit of a third person. Any representation that a third person is solvent or capable of performing such a particular obligation must be in writing. This is akin to being a guarantor or a surety or a co-maker, a co-obligor. But such an assumption of undertaking or responsibility is required to be in writing in order for the creditor to enforce the obligation insofar as that person making the representation is concerned. And the last kind of defective contract is what we call as void contract. Void meaning it is not valid. Void meaning it has never existed at all. Ab initio meaning from the very beginning, it never became a perfected contract. What are the general types of a void contract? Any contract entered into when the stipulation is contrary to law, morals, good customs, public order, or public policy. While it is a general characteristic of a contract to be autonomous in terms of the parties' capability to stipulate on any terms and conditions of their agreement or contract, when such stipulation is contrary to law, morals, good customs, public order, or public policy, it is not covered by autonomy of contracts anymore because the contract is void ab initio. As we talked about earlier, when a contract is absolutely simulated or fictitious, the contract is void. Well, again, by way of review, you have to distinguish this with a mere partially or relatively simulated contract, which is valid. But an absolutely simulated or fictitious contract is void. When the object of the contract or the cause has never existed or did not exist at the time of the perfection of the contract, when consent was given by the two parties, it is a void contract because they cannot agree on something that does not exist. When the object or the subject matter of a contract where consent was given is outside the commerce of man. We had been talking about this from day one of obligations and contracts discussion because we can only sell property and make as a subject matter of an obligation or contract those which are within the commerce of men. There are things that cannot be sold or that cannot be a subject matter of an agreement. Impossible service is also considered as a subject matter of a void contract. When the intention of the parties relative to the principal object cannot be ascertained, it is void because the parties while they have given consent, do not really know what is the consent all about. For example, I offered to deliver to you a specific object, and you accepted my offer that I will deliver to you that determinate object. While it is true that both of us have agreed on the object and on the fact that the object shall be delivered by me to you, but what is the purpose of the delivery? Why will I deliver to you the object? What will you do with the object? Will there be a transfer of ownership? Will it just be for rent? Will it just be for a specific purpose other than sale or rent? While we have agreed that there will be delivery of a determinate object from me to you, our intention, insofar as the object is concerned, cannot be ascertained by such an agreement. Even if consent was given on the object that was given, the cause or consideration, the why, has not been answered. And therefore, there being an essential requisite of a contract that is lacking cause or consideration, the contract cannot be valid, and therefore, it is considered as void. Why? Because the one that is lacking is an essential element of a contract, cause or consideration. When an object, which is the subject matter of the contract, is expressly prohibited or declared void by law, then it cannot be considered as valid. The subject matter being illegal renders the contract void. Why? For lack or absence of an essential requisite of a contract, which is having a valid object. And so with consent. If consent is totally absent, not having been given by one of the parties or both, then the contract is void. Why? Because there is absence of an essential requisite of a contract, which is consent. Remember, consent is totally absent. That's why the contract is rendered void. But by way of review, when consent is present, but it was defectively given, it will be voidable if it affected only one party, and it will be unenforceable if it affects both parties to a contract. What are the remedies in case of void contracts, particularly on the injured parties or the aggrieved parties? Unlike the other kinds of defective contracts, in case of a void contract, the injured party cannot ratify a void contract. Once void, it is not ratifiable. In relation to void contracts, we have to consider also compound contracts or compound obligations arising from contracts. In obligations, we talked about that in compound obligations or contracts, it is possible that these contracts may be divisible or indivisible. So if among the compound contracts, Some portions are void, some portions are valid or defective. You have to check, are they separable? Because the effect of divisibility is that only the void contracts will be treated as void, while the portions which are legal or at least defective, they can't be treated as void. But that is only in case the portions in the contract are separable or divisible. That ends our discussion on contracts, and that also concludes our discussion of the law on obligations and contracts this term. Congratulations in advance, and do your best in the final exam. Thank you.